Okay, I think we are all set up. Things seem to be working. So good morning again. We've got a calendar this morning that's mostly plea and arraignment, but we've got a status conference and sort of a bond hearing, but it sounds like everyone agreed on the bond hearing. So we'll work through that. Plea and arraignment position 1 is Tawana Stillwell.
Good morning, Attorney Stillwell. She just texted her office and said that she's being robbed. It was an accident, so she's delayed in traffic issues and
But she does plan on being here.
Correct.
Excellent. Well, thank you, Ms. Edwards, for being here. Other than handling the arraignment today, I wanted to work through, and I'll have to look at the docket again. I was trying to pull it up right now. I want to make sure Ms. Stillwell has a bond on all counts, because I think she had a bond set. It may have been Judge Glanville. If I'm remembering the correct case on my calendar, he kept modifying bonds, but it was for not all the counts in the indictment. And so it may be that Ms. Stillwell technically is walking around with no bond on some of her counts. And we need to fix that. If the state had agreed to bond, then that's probably the situation that will maintain. Am I remembering the right defendant? Okay.
And it appears that it may have been two separate indictments, two different indictment numbers, and I think that may have been because it started as an aggravated assault.
Correct.
Murder. Now it looks like there's 2 counts of murder. I don't know if they were on 2 different numbers and then came together.
We'll need to work through that this morning. So when your client gets here, let me know and we'll handle that. You too. Position 2 is Philip Thomas.
Good morning, Your Honor. Chinwe Foster from Mr. Thomas. He is on Zoom.
Okay.
Good morning, Judge. Michael Costello from the DeKalb County District Attorney's Office. I'll be on behalf of the state for that case. I'm sure Your Honor may have been made aware by Ms. Nelson, but this is a conflict case that Madam DA Willis's office had a conflict off of, and Madam DA Boston has been appointed by the Attorney General.
I actually learned through Ms. Foster, something she filed. So I'm curious and we can talk about that, but we've got everyone in place here. So why don't we talk about Mr. Thomas's case? I need Mr. Thomas on the screen here. Let me make that happen. So there is Ms. Foster and Mr. Thomas. Let's add him. There he is. How you doing, Mr. Thomas?
Good morning, Your Honor. Yes, sir.
I'm Judge McBurney. It's nice to meet you. And Ms. Foster, thank you for being here. And Mr. Costello, thank you for being here. A little bit more of a commute than some of your brethren here on the prosecution side. Why don't we start? You're welcome to take a seat.
Thank you, Judge.
Why don't we start by having you tell me what the conflict was from the Fulton DA's office, if you know.
Yes, Judge, I am aware of the conflict. So I don't want to get too much into the facts, Judge, but this is a case where somebody was shot, and it is alleged that the defendant called a attorney in the DA's office and made some potentially incriminating statements before the incident and then also after the incident.
Okay, so we need to wall that office off. And just out of a abundance of caution, because there may be that evidence out there, it's cleaner for everyone to have a nearby jurisdiction handle it.
That's correct, Judge.
Will you be, as long as things stay stable, will you be the prosecutor on it, or it's just they're grabbing who they can from DeKalb as we have calendars?
This is my case, Judge. I'm the one that investigated it. I indicted it, and I'm prepared to try it.
Excellent. Okay. Well, we'll see if it goes that far. Ms. Foster, you may have heard my brief conversation with Ms. Edwards about her client. I think your client's in the same position. And here I'm referring to Mr. Thomas has a bond, but that bond is not for all the counts that are in the indictment. Let me call up his case now. He got a bond when this was an unindicted matter. And so it was a bond for, let's find it. So his bond that he got a long time ago, May of 2021, was for $15,000 from Judge Oliver, and it was for aggravated assault and possession of a firearm during commission of a felony. His indictment has other counts, and he has no bond for those counts. So one thing we need to talk about today is how to handle that, because technically Mr. Thomas has no bond and should not be in circulation. I don't think that's how things will play out, but we need to work through that. And then I want to confirm, Ms. Foster, that you have filed both speedy trial demand, meaning a statutory speedy trial demand, and an immunity motion. Is that correct?
That is correct, Your Honor. And we also have a motion to suppress statements that we will be filing. I believe it was already filed today, as well as a motion to compel, but I can speak with Mr. Costello about that. It's just a 911 call that we're missing.
Okay. Did you know that Mr. Costello was the prosecutor on the case before today, or is this your first time connecting with him?
No, Your Honor, I've spoken with him previously.
Great. Okay. Well, the way it works in my division is we'll handle arraignment, whether you're waiving it, Ms. Foster, on behalf of your client, or whether we're formally arraigning Mr. Thomas. And then I will enter a scheduling order that will set a deadline for disclosure of discovery that Mr. Costello has at this point. It may be, I'm making this up, you don't have ballistics back from GBI. Well, you can't hand that over yet then. But everything you do have, there'll be a deadline to get it to Ms. Foster. Ms. Foster, you'll have a later deadline to file any other evidentiary motions. So you're ahead of the curve with the immunity motion, and you'll be ahead of the curve if you file the motion to suppress statements. It's really not due until a date you'll get in a scheduling order that will come out probably on Monday or Tuesday. But you're welcome to file it anytime before that deadline. We'll certainly need to calendar the immunity motion, and be my preference to work through all the motions in one hearing. So we may wait a little bit to see what the suppression motion looks like as well. The speedy is a placeholder only right now. We have on the Chief Justice's desk, our circuit does, a order that Chief Judge Glanville signed that if the Chief Justice approves, will extend the tolling of the speedy trial clocks, the statutory speedy trial clocks, through the end of the late July. So that doesn't mean we in any way need to move slowly with Mr. Thomas's case, but just to inform Mr. Costello, there isn't a clock that would start running in terms of a term plus one until either the Chief Justice tells us I decline to endorse Chief Judge Glanville's order, or at the end of July. So we'll keep moving this forward, and as long as both sides are ready, I'm happy to have it on sort of next available calendars. I'd like to talk about bond, but let me start, Ms. Foster, by asking you if Mr. Thomas is waiving arraignment or if he wants to be formally arraigned.
We'll waive arraignment, Your Honor.
Okay. I'm going to ask you to file a waiver of arraignment form. Ms. Nelson can send you, we've got a standard form, and she'll send you, that's my litigation manager, she will send you that form. If you would execute that and get it e-filed, that will trigger the scheduling order that will give both sides the deadlines for discovery, motions, et cetera. Let's talk about bond. Mr. Costello, what are your thoughts about how we ought to manage this? Again, Judge Oliver's bond was for arguably 2 of the 5 counts in the indictment. It's the same situation, and unless you've learned something that makes it a much more serious investigation, for example, poor Miss Stillwell, it was an aggravated assault, and then it became a murder, allegedly, because the person shot died. Doesn't sound like that's this case.
And you're correct, Judge. The state has no intent to hold Mr. Thomas prior to trial. These were facts that were known right away. They should have been charged this way initially. However, they weren't. He has a very limited criminal history. I don't believe he's a flight risk. I think he has significant ties to the community. So, I mean, I don't know if we can, I don't know what the procedural aspect would be to like extend that bond throughout all 5 of them, or it's not our intent to make him pay any more money or spend any more time in custody.
Or be booked back in.
That's correct.
Okay,
Judge.
Got it. That would be my perspective as well, but I come in knowing nothing about it. You knew a lot more, and it does sometimes arise where a prosecutor says, actually, because things have changed, either we need a bigger bond amount or nope, I don't think there should be a bond, but there was no grand jury warrant. So that said to me that this was probably just a administrative disconnect. There are two people from whom Mr. Thomas is to stay away, a Christopher Swain and a Kendrick Cooper. Does that condition need to remain in whatever revised bond we do?
That would be correct, Judge.
Okay. Are those people that you believe are relatives or close friends of Mr. Thomas, or clearly they're connected with the case, but a stay away doesn't seem like it's particularly complicated to you?
It's the two alleged victims in the case, Judge. I believe that Mr. Swain and Mr. Thomas are longtime friends and acquaintances. Mr. Cooper and Mr. Thomas are not.
Okay.
And Mr. Cooper is also out of state, Judge. He lives in Texas. So I don't think that there's necessarily a big issue there.
Okay. Ms. Foster, what are your thoughts about how we manage this bond situation?
Yeah, I agree that it should be extended. However, I just want to bring some things to the court's attention. Mr. Costello mentioned that my client has a limited criminal history. He has no criminal history. He's a professor at Morehouse. I want to clarify that because he wants to bring up a traffic ticket on his record. I just want to make it clear to the court, my client has no criminal history whatsoever. Furthermore, Your Honor, my client is charged with 2 possession of firearms. We did file a demurrer. There was only 1 firearm, so that's an issue. But for purposes of bond, Your Honor, we're fine with extending the bond through all the charges.
Okay, so what I'll do.
No issue with stay away as well.
Okay, good. I will work with Ms. Nelson, my litigation manager, and figure out with the sheriff's office as well the cleanest way to do it. My intent would be to keep the bond in place and just have the $15,000 bond that Professor Thomas did post to cover all 5 counts. That seems consistent with what Mr. Costello is advocating and what you just asked for, Ms. Foster. So I'll figure out how to do that, but I think I may need to enter a new bond order and so that it's just plain in the docket that all 5 counts are covered. This bond order that I'm referring to from May of 2 years ago from Judge Oliver is actually when it was just a CP, an unindicted matter. So what I enter will be connected to the indictment. I'm looking for this demur because we'll need to work through that as well.
Your Honor, Attorney Hawkins is with my office. She is my co-counsel on this case. I believe she can clarify that for the court.
Okay. Hey, Ms. Hawkins, how are you?
Good morning. I'm fine. How are you, Judge?
I'm well.
It will be filed today.
Okay, so there is a demur coming,
Yes.
just like there's a motion to suppress coming. Okay.
I'll be sent to Ms. Nelson by close of business today.
Okay. Again, no rush. Happy to get it today, but the motion's deadline is going to be established in the scheduling order. Is it your sense, Ms. Hawkins, that the demur is something that could be addressed just on the pleadings, meaning you'll file a motion and Mr. Costello can file a response? Or is it the kind of thing where we'd need to receive evidence? If it's more of a, I don't remember what it is, multiplicity or duplicity, because there are 2 counts that are effectively charging the same thing, seems like we could resolve that on paper rather than add that to the hearing for immunity and motion to suppress.
Yes, Your Honor. It's just an issue, in my opinion, of the unit of prosecution. So I think that it could be argued on paper.
Okay. All right. Well, Mr. Costello, you'll get direction from me as to whether I need a response. But if I do send something your way, obviously CCing defense counsel, that'll be my sign that I think we can sort out at least the demur just by getting a response from the state.
Yes, Judge.
I think that covers everything. Mr. Costello, did you have anything else on behalf of the state?
No, Judge, I would agree with defense. I think that the motion to suppress defense would be related to statements made by the defendant to law enforcement, so Jackson Deno on those 4 statements. I know for those 4 statements, I can tell you that the state would need to call 3 witnesses for the 4 statements. And with, your boilerplate Jackson Deno questions, I would anticipate that hearing to be roughly 2 hours.
Okay. Anything else?
And as far as the immunity motion, Judge, I can already tell you that the state would call probably 8 witnesses for the immunity motion. So I'm not sure how many the defense would call.
Not a short hearing.
No, sir.
Okay. All right. Ms. Foster, what other things do we need to cover today in connection with Professor Thomas?
Nothing else today, Your Honor.
What would your estimate be as to how long the immunity motion would take to hear?
Probably at least a day and a half.
Okay. All right. We'll look for that day and a half somewhere. Do you envision filing a response to the motion, Mr. Costello, or after the hearing, we can have a discussion about whether people want to file post-hearing briefs? Or do you think that Ms. Foster's motion tees it up and then we'll just hear from the witnesses and have argument at the end?
I think we just need to hear from the witnesses, Judge.
Okay, got it. Ms. Hawkins, anything else from the defense?
No, Your Honor.
All right. Professor Thomas, do you have any questions of me? Not about the facts of your case, but just procedure or anything we talked about today that wasn't clear to you?
No, Your Honor.
Okay. You understand that that bond that Judge Oliver entered way back in May of 2021 remains in effect. All I'm going to be doing is having that dollar amount apply to the 5 counts of your indictment. I won't change the conditions at all. So you'll still need to let people know if you move, you'll need to stay away from Mr. Swain and Mr. Cooper, and no weapons in your household. Do you understand all that?
Yes, Your Honor.
Excellent. All right. Well, if there is nothing else, then Ms. Foster, we'll look for that waiver of arraignment. We need to get you our form. But once you get that, if you'd fill that out and e-file it, that'll get everything rolling on our side. And we'll start scouring the calendar for kind of a couple days for the immunity hearing as well as the suppression motion. I may decide to make that 2 parts and we do the immunity hearing first, because if you prevail, Ms. Foster, then we don't need to have the suppression hearing. And so just given what Mr. Costello said, that it's not going to be a 20-minute Jackson Deno, but might be more of an hour plus because it's 4 statements, 3 witnesses. We ought to conserve our resources and focus on immunity first, unless that gives anyone heartburn. No? All right, excellent. Well, thank you, everyone. Professor Thomas, you are free to go, and we'll be in touch with everyone. Okay?
Thank you, Judge.
Thanks.
Thank you, Your Honor.
Bye-bye.
Thank you, Judge. That's my only matter. May I be excused?
I hope it's the only matter here. Yes, you may. Are you assigned to a particular judge in DeKalb, or you're in a unit and you flow around? I know no one's in the building right now, but.
No, I'm with Judge Barry.
Okay, excellent.
So unfortunately, we're not going to be having any trials in the near future.
So I've heard. We are all grateful that the state court judge went in the building when he did. It would have been a lot worse.
It probably would have.
I don't know what he was doing there on Christmas Eve, but thankfully he was there.
All right. Thank you, Judge.
Nice meeting you.
Nice meeting you.
Ms. Edwards, any update on Ms. Stillwell?
Your Honor, Ms. Stillwell is present.
Great. Good morning, Ms. Stillwell.
Good morning.
I'm Judge McBurney. It's nice to meet you. Who is handling the arraignment for the state? You look over your shoulder and see no one.
Yes, Your Honor. I believe that would be ADA Adam Abate. I'll reach out to him.
Okay, please do. I don't want to keep Ms. Edwards and her client waiting too much, but why don't you do that? So at least we've got someone who, if I've got questions or Ms. Edwards does, in a better position than you to answer them.
Yes, Your Honor.
All right. So Ms. Edwards, we'll figure out where Mr. Abate is. If the answer is he can't be here for a while, then I'm going to ask Mr. Jordan to handle the arraignment. You bet. Next up is Emilio Grulan Paniagua, and I've not pronounced his last name real well. Are these 3 folks in custody? No. Okay. They all have a W next to their name. Says there's a warrant. They all have warrants. Are these grand jury warrants? They haven't been here before, so it wouldn't be a bench warrant. What do you know?
Your Honor, from my understanding is that they originally received bond back in 2020. I think when the state indicted the case, there were charges that were added that I don't believe they have bond for yet, which may have led from the grand jury warrants.
So it's grand jury warrants.
I believe so.
All right, I'm gonna look up at least one of these. Ms. Primovic, good morning. Thank you for being here because I know Ms. Feely has some things to be working on. You represent Mr. Burkott Dukes.
Correct. And I believe he was a bench warrant, in pre-indictment also.
Okay, someone just stood up.
Hi, I'm Shannon Campbell from Campbell Bonding. We are the surety on this bond. And actually, I had been trying to reach out to,
The defense?
yes.
Okay,
Yes. And Mr. Dukes is in contact. He had called when I exited the room just a second ago. So I am definitely in touch with him.
Oh.
And would like the chance to speak with her if possible.
you guys certainly can speak. Mr. Dukes showing up would be a good thing. Let me just pull this case up so I know a little bit more about it. You're welcome. All right, so we'll just look at Mr. Dukes. All right, so he received a bond from Judge Rickman back in October of 2020, $57,000 with an ankle monitor. Oh, Mr. Dukes may be in Colorado. Is that what you're hearing, Ms. Cagle?
Yes, Your Honor, that is correct.
Okay.
He is in Colorado and unfortunately, he was shot back in November. Some kids robbing a store or trying to rob him at a gas station after work one day. So that is why he has not been or is not in attendance this morning.
Okay, well, that's ironic given the charges here. I hope he's okay. His family, Mr. Jordan and Ms. Primovic has also been contacting Ms. Nelson. So Mr. Dukes at least seems to be trying to surface. Well, there are various versions of events that Mr. Dukes' family is relaying either to Ms. Cagle or Ms. Nelson. But either way, there are people out there maybe trying to connect him with us.
Hospital bills, or his hospital stay, Your Honor, so I do know that those facts are true.
Okay, well, best is for you to speak with Ms. Primovic because the best, most formal advocate for Mr. Dukes will be Ms. Primovic or one of her colleagues. So when we're done with this calendar, you which will be soon, you two can talk. I just wanted to see what we were working with here. So I guess what we'll do is put position 3 in judicial hold because there is a grand jury warrant for Emilio. We won't put Mr. Dukes in judicial hold quite yet because we'll let Ms. Cagle get to Ms. Primovic all the information she has so that the public defender's office can say, we'd like to get him in here, and maybe you'd lift the grand jury warrant. So that brings us to the third defendant in the case, Keandre Logan. Anyone here for Mr. Logan? All right, so I guess that'll be judicial hold as well. And you believe, Mr. Jordan, there's a good, as in it would be enforced by law enforcement warrant out there. If Keandre Logan gets pulled over for speeding, this warrant would grab him.
Yes, Your Honor, and Ms. Primovic was correct. Mr. Logan appears to never have been arrested on these charges.
Okay, whereas Mr. Gruyan was, because he's got a bond through second chance bail bonds. They are less resourceful than Reggie Cagle bonding. They're not here. So we'll do judicial hold for Mr. Gruyan, judicial hold for Mr. Logan, and we will do, Ms. Primovic, should we just do one reset for Mr. Dukes, but set that out a little bit if he Maybe is it, yeah, something. Okay, you bet. And Ms. Cagle, if you don't mind waiting just to speak with Ms. Primovic, that would be helpful.
I'm just gonna step out, call it that back real quick.
Okay.
Thank you.
All right. Next up then is Jaquante Campbell, who I hope is here. He is here, and we need Mr. Kennedy, who is here. How you doing, Mr. Kennedy?
Pretty good. How are you, Jake?
I am well, and I am particularly excited to see, I'm happy to see everyone here in court, but poor Mr. Campbell, you're one of our C3 participants, so thank you for that. But Mr. Campbell has been lawyerless for a while. And I don't know how much time you've been able to spend with him or Mr. Jordan. And we'll bring Mr. Campbell out in 1 second. I just want to give you real brief context. Mr. Campbell was finger to thumbs distance away from entering a plea before Mr. Bowles represented him and even was willing to stay on, even though he was beginning to shift his business to New York to get closure on that. And Mr. Campbell, even though his co-defendant pled, couldn't quite pull that trigger. Ms. McCauley from the DA's office has really mastered this case and gave a very helpful presentation when Mr. Hill pled. So I feel pretty knowledgeable about it just because of that plea colloquy. And Mr. Campbell and I and Mr. Bowles were that close. But it wasn't what Mr. Campbell had in his heart at that point. I share that with you, not because you now need to follow in those footsteps. You may be here to say, we want a trial. That's okay. Mr. Campbell drives that bus with your assistance. But I just wanted you to know where I'm picking up from, which is, gosh darn it, we couldn't get a lawyer for Mr. Campbell. Not his fault. Now we have one. And if we were just picking up where we left off, it was Mr. Bowles saying, no, I'm pretty sure we can work this out. And then it was getting a prosecutor up to speed because it's a sprawling case. And Ms. McCauley was able to do that, but then she got pulled in another direction. So I'll bring Mr. Campbell out in 1 second. I just wanted to get your sense before he's out here of where you think you and he are heading.
I was going to say, Judge, it sounds like you are more familiar with the background of this case than I am. And I thank you for giving me that insight. I would like the chance to, discuss this case with Mr. Campbell. I've had some conversations with some family members, but still need to get more up to speed on the specifics.
Okay. Well, today was a status conference to figure out, do you have all the discovery? I hope you do. If you don't, Mr. Jordan will get it to you, but it was already in a nice package for Mr. Bowles. Again, he was ready to plead the case out, not thinking, oh, if I don't, then I need to get all the discovery. He had it all. Ms. McCauley, unsurprisingly, had it pretty locked down about what happened. And admittedly, I was sort of scratching my head. Other than it's never easy to say I'm going to go to jail for a while. Mr. Campbell's other option didn't look to me to be very attractive, i.e. going to trial. So we do need to bring him out and have some conversation. Where do you see us going next?
Well, I believe I have just received discovery. I'd like a chance to review it. I would just ask that we keep this case in a pretrial, Your Honor.
Okay. Well, why don't we bring Mr. Campbell out and we'll talk about, next steps. Mr. Jordan, was there anything you wanted to add before he came out?
Just in regards to discovery, since this is an older case, there's no digital discovery that was uploaded to evidence.com. So today, when I go back to my office, if I can just transpose all that information and send it to Attorney Kennedy, I'm sure that we can get it to him today.
Great.
It's as you said, it's a packet and it's in CDs and DVDs.
Yeah.
Nothing that was transposed just yet.
It is, in some ways, Mr. Kennedy, it's going to seem overwhelming, but in other ways, just to reassure you, it's somewhat repetitive in that these two, there's a female charged who's a fugitive, but her role was a little different. But Campbell and Hill, it was sort of a repetitive event in which they engaged.
Oh.
So it's going to be a series of the same kinds of things, breaking into cars, things like that.
Thank you for the heads up.
You bet. Why don't you go sit with Mr. Campbell? Good morning, Mr. Campbell. It's been a minute. How you been? Are you held in Cobb? Is that why you're wearing orange? Okay, all right. Mr. Campbell, for a number of months, through no fault of your own, you've had no lawyer. We've been working hard on the court side to try to line up legal resources for people in your situation. Someone who had what we called a C3 lawyer. Since there are 3 defendants here, one has the public defender, one has the conflict defender. Mr. Hill had the conflict defender, and you had Mr. Bowles. Mr. Bowles stopped filling that role of a C3 lawyer, but we have been able to encourage other experienced criminal defense attorneys to raise their hand to say, hey, we'll help out with this. And Mr. Kennedy, who is seated next to you and has spent some time with some of your family members, was one of those lawyers, and he was assigned to your case. I spoke with him for a few minutes before we brought you out here, just letting him know where I thought we left off with the case. And that was I met you before. You were close to maybe working the case out, but you weren't in the end willing to pursue the offer that the state had made at the time. Mr. Kennedy is going to get up to speed with all the evidence. Mr. Jordan, who's the gentleman seated 2 away from you, is the prosecutor who now has the case. Ms. McCauley, who you met before, is still connected with the case and can be brought in if we need to refresh anyone's recollection as to what offers were, what this case was about. But the 2 lawyers I'll be working with will be yours, Mr. Kennedy, and then Mr. Jordan as the prosecutor. And I just spent a few minutes talking with both them before we brought you out to figure out, well, what can we do next? Because you've been sitting in jail forever. And so either we need to get you in here, get 12 jurors in the box and try this case, or you need to resolve it short of trial. Mr. Kennedy has understandably asked for a little time to meet with you and to wrap his arms around the discovery. There's a lot of discovery because there are a lot of different events that are all tied up in this one long indictment. Mr. Jordan, how long do you think it will take to package up the discovery and make it available to Mr. Kennedy?
No longer than a week, Judge.
Okay. Mr. Kennedy, how far out would you like us to reset this for? Today was supposed to be, I didn't know how new you were to the case. Today was supposed to be when I asked you, do you have all the discovery? Is this being resolved with a plea? Because after, and we'll reset this, but when we next meet will be the status conference. And that's when you confirm you've got all the discovery, or if there's something missing, it's not something the state can get you, but you could get it. That will be the last day for Mr. Campbell to enter a plea that he could withdraw if he doesn't like the sentence I give him. So it may well be something negotiated. I'm not bound by that. I'm making numbers up. If it was negotiated 3 years to serve, and I look at all these events and say, you know what, I'm going to give him 5, Mr. Campbell could say, well, I'm withdrawing because 3 was what I had asked for. And I said 5. After that day, of course, Mr. Campbell could enter a plea. He just couldn't withdraw his plea if he got a sentence he didn't like. Just like if we go to trial, you don't get to withdraw anything if you don't like the sentence that you get. But when we meet again, I'll be exploring with you, do you have all the discovery? And is there a plea that we'd be taking that day, at which time Mr. Campbell would have that right to withdraw his plea if he was unsatisfied with the sentence that I gave him? Does that make sense?
Yes, sir. Thank you, Judge.
Mr. Camp, oh, so I need you to answer my question then, which was way at the beginning of that. How far out should we reset this status conference? Assume you get all the discovery in a week. We'll have to move it even further out if Mr. Jordan says, oh my gosh, I can't get discovery for 3 weeks. But assume you get discovery by the end of next week. How far out in time do you want me to reset the status conference?
Yeah, I wouldn't expect it would take me longer than 30 days on receipt of the discovery.
To go through it and to spend time with Mr. Campbell?
Yes, sir.
Okay, because again, when we meet again, part of that discussion will be, are we working this out where Mr. Campbell may want to exercise that right to withdraw his plea?
Okay.
All right.
Thank you.
So what we'll do, Mr. Campbell, is reset this status conference for early to mid-February. At that time, I'll expect Mr. Kennedy to give me an update on discovery, and we'll see if there is some kind of plea that's been arranged that you'd be interested in pursuing. And if there's not, that's okay. The next stop after the status conference is to get the case on a trial calendar. This would be a priority case. It's old and you're in custody. That makes it number one on my list. So if it's not resolved at our status conference, then everyone should expect it to appear on the next available trial calendar. Okay? Mr. Jordan, anything else for the state?
Nothing further from the state, Judge.
Please let me and Ms. Nelson know if, and obviously Mr. Kennedy, if you look at that discovery and realize end of next week is not a realistic deadline for getting it to Mr. Kennedy.
Absolutely, Your Honor.
And by getting it to him, it sounds like, will it go up into evidence.com, or this, because the case is old, for some reason you can't do that?
I should be able to, because I looked at the discovery that ADA McCauley filed. I should be able to transpose pretty much everything and put it on evidence.com. That way, Attorney Kennedy should be able to view everything a little bit quicker.
Okay. Mr. Kennedy, are you experienced in the evidence.com discovery exchange process?
I'm not, Your Honor. Practice primarily out of Cobb County and Cherokee County, and we're not too familiar with that program.
Okay, just make sure you explain that to, and before you two depart today, please exchange contact information. But my limited understanding of it is that you'll get a link and you click on that link and all of a sudden there's a whole file directory and everything that is digitized. So videos, all the police reports, because they've been scanned, are there, and you can download all that, and then you've got a digital version of Mr. Jordan's file. It works well when it works. So we'll need to make sure you're able to get into it and make it work. So I just want to make sure you guys are connecting. Okay.
And Your Honor, if evidence.com doesn't work for Attorney Kennedy, I'll be sure to upload it to a jump drive and just make sure that he gets possession of it.
Okay.
Perfect.
Understood. Great. Mr. Campbell, do you have any questions for me about your situation? Okay. Then look for Mr. Kennedy to come visit you at Cobb. I guess if you handle things in Cobb, that's going to make it, you know that facility. As you now probably know, we have a handful of inmates who we house at Cobb because of issues in the Fulton County Jail. And Mr. Campbell's one of them. So that's where you'll find him. Great. If no one has any other questions, we'll reset this for mid-February. And I look forward to getting a meaningful update then.
Thank you, sir.
All right. So Mr. Rao was here and then Mr. Rao left. Now he's back. Are you going to be Mr. Abate for today?
Judge, actually, this case is assigned to the domestic violence unit, which I am now the interim supervisor of.
Well, congratulations on the promotion.
Thanks. I can't wait for Ms. Hilton to come back.
Yeah, so I wouldn't rush on that one.
Right. So this case will actually be assigned to Mr. Whitenauer.
Okay.
I'll just be here.
Oh, I think he may have walked in here for a minute too.
Yeah, he may have.
He's got another.
Yeah, to go to Dunaway this morning.
Okay, well, we've got someone. So Ms. Edwards, if you and Ms. Stillwell will come on up to defense counsel table, please.
Judge, this matter is all I have.
Yes, sir. Thank you again for participating in this program.
You're welcome, Judge.
If you run into any logistical issues with the program, not this case, you bug Mr. Jordan, but with the program, if you're not getting reimbursed or anything, please do reach out so we can make sure it's working.
Okay.
All right. How many cases have you received through it so far?
This was my first case and I just got my second one just last week.
Okay. And so far that's 2 cases is manageable. Could you take more?
I could.
Okay. We're thinking about restocking the wheel and pushing more out.
Okay. It's a very similar program to what we have in Cobb County with the Circuit Defender's Office.
We consulted with them.
Oh, really?
Yeah.
Okay.
All right. Good to meet you. Okay. Hello, Ms. Stillwell. Mr. Rao, what I flagged for Ms. Edwards is a bond concern. Judge Glanville gave Ms. Stillwell a bond a while ago, but it is not for murder. And so we need to work through, let me pull up her case here.
Right, she actually does have a bond on the murder. Originally, I believe he may have given the first one, I'm not sure, but she was originally arrested on an ag assault, bonded out, and then shortly thereafter, the victim passed, and so she went back into custody and bonded out on 1 count of murder.
Oh,
Now it looks like they have 2 murders and some other charges that were added on after the fact, and that is what does not have a bond, the additional charges, but she has been arrested twice and bonded out twice.
okay. Well, thank you for correcting that. Let me look at what the docket shows, because that's what I was working off of.
Correct.
Is the CP case still hanging out there? Is it the same case?
Same facts, but there's.
How many dead bodies are there?
1.
One, okay.
One shooting, 1 situation,
Okay,
but there's apparently 2 murders.
so I'm looking, we'll just take it one step at a time. In November of 2020,
Mhm.
Judge Ashley gave Ms. Stillwell a $30,000 bond. Stay away from, is Keen or Kean? Keen O'Kelly?
Yes,
How do you pronounce the first name?
Keon,
Keon. Is that a male or a female?
male,
Is that the deceased?
correct,
Okay, so Mr. O'Kelly, so at that point, Mr. O'Kelly was still alive
correct.
and Ms. Stillwell needed to stay away from Mr. O'Kelly. And that's for 1 count of aggravated assault.
Correct.
Then in December, Ms. Edwards, you filed a motion for bond. Because she'd been rearrested.
Correct, he passed away a few days later.
Got it. So there's your motion for bond. So the docket for the indictment shows your motion for bond. It doesn't show any other bond having been entered. But Ms. Nelson tells me that the CP case is somehow still open. And so that's probably where I'll find the bond you're talking about. So
Correct.
let me look for that.
Not only has she been given a bond, we've actually modified the bond twice.
Huh, okay, and that's been with me?
No, that was with Judge Glanville.
Okay, I could have sworn there was Judge Glanville in the mix.
Correct, we modified the bond.
All right, so now I'm looking up the CP case and it dumps me back into this. But I saw the bond modification. That's how I was able to bring this up with you. Hey, Mr. Abate, the case on here is actually Mr. Whitenauer's. You're welcome to be here. Okay, well, he's a supervisor now. People don't need to wait on him. Yeah.
I have 2 different CP.
Okay, great. Share with me the other CP number.
20 CP 1955552.
Yes, that one is still a CP number. The one from your motion to modify the bond or whatnot dumps you back into the indictment. So that complaint number, the CP number you didn't give me has been extinguished. But the one you just gave me that ends in 552 is alive and well. And we'll need to make it go away. But that's where in just 2 months ago, Judge Glanville, so this was the bond I was seeing, that was $40,000 that was all building off of, but it says charged with 1 count of murder. So I guess there were 2 complaints. There was the complaint that said aggravated assault. And then when Mr. O'Kelly passed, then there was a new complaint that said murder. And that's all it said, 1 count of murder. And there's a $40,000 bond curfew. And this is what you were getting modified, so that Ms. Stillwell could travel for work. Okay. We'll work off of whatever bond we need to work off of. We do need to link up that CP number with this indictment number.
And then when I was looking at the calendar, it says 2 counts of murder, which is the first count stating that.
I'm going to look at the indictment in just a second, because really we're here for arraignment and we need to do that. Ms. Stillwell, we're not always this confused by things. So don't despair.
So one count of murder, one count of felony murder, Judge.
Right. I'm looking at the indictment now. I'll print a, do you have a copy of the indictment? All right. I'll print out a copy for you to have. But count one is the murder of Mr. O'Kelly. Count two, felony murder, the aggravated assault. Then we've got the aggravated assault, count three, and then it's possession of a firearm during commission of a felony. So it's the four pieces you always see in a murder where the person doesn't have a prior felony. So serious charges, serious situation, but fairly standard charging language. And there's only one count of murder. We still need to figure out what to do with bond so Ms. Stillwell doesn't get caught up in a you have no bond on felony murder, aggravated assault, or the firearms charge. Let me print first. Mr. Rao, my proposal is to do exactly what we did in the Professor Thomas case that DeKalb is covering, which is, I don't know technically how we do it, but on my end, it would be to enter a new bond, get Glanville out of the mix, but that bond would be for the dollar amount that I don't know if the state consented to it or not, so you can get me up to speed on that. But there's this $40,000 amount that Judge Glanville entered and then modified. He didn't modify the dollar amount, but the conditions were modified a few times to address, one, the stability that Ms. Stillwell was showing, but her needs to travel for work. And so it seems like that dollar amount ought to be spread across the four counts because he gave her that bond for murder. The counts for which there is no bond aren't new victims, but they're all effectively subsets of that murder charge.
I would agree that that was probably Judge Glanville's intent to whatever the charges would be, that the overall bond would have been $40,000. I'm unaware as to whether or not we consented to it. I would have hard time.
I'm going to look.
It was considered on that budget.
Okay.
Was a consent bond, in terms of the modification, we just filed it and it was just easier to get on the calendar and to try to catch up with people, so we filed it.
Yep.
And still ended up consenting before the judge to working out the modifications.
So there was no bond initially from Judge Glanville, and that was in January of last year. Then consent order for bond, there it is in June. So Ms. Stillwell was in for 5-6 months. Okay, and then $40,000 through 10% program or property or surety. And Pat Dutcher, it's a pretty official name.
I did see the last amended order was on February 18th of last year with Mr. Dutcher's name.
Yeah, well, actually, the most recent one was less than 2 months ago. Third amended consent bond order, and Ms. Hilton, who you would really like to come back and replace you, she signed off on that. Didn't change the dollar amount. Again, I think it allowed Ms. Stillwell to travel for work, but regardless, your office has consistently consented to that dollar amount. I don't know. How did you make the bond, Ms. Stillwell? Is it property? Was it property? Okay. So we'll need to work with you, Ms. Edwards, with the logistics of changing the bond. And again, it's just spreading the dollar amount. The conditions will remain. I will incorporate the conditions that we see in that November 1, 2022 order from Judge Glanville and work from that. What about arraignment? Are you waiving arraignment for, let me give you the indictment, so you know exactly what Ms. Stillwell's being arraigned on.
We are aware, Judge. We are aware.
And Judge, just for the court certification, I think when the state indicted it to include the felony murder charge, I think there was a purposeful intent not to pursue grand jury warrants. So I don't think there's there's necessarily a warrant out for the felony murder.
There's not, but we have 3 charges for which there's no bond, and that can create issues for folks. When we've got a charge as serious as murder, I don't like no bond charges floating around out there if something unfortunate happens.
Understood.
So we'll figure out logistically how to fix it, and just circle back with the parties, because I think it will continue to be a consent bond. That's what I'm hearing, and that would be consistent with what the DA's office has been doing. And there seems to be no evidence that Ms. Stillwell has had any issues while she's been out on bond. Are you subject to pretrial supervision, Ms. Stillwell?
Yes, every week.
Good. Okay, that makes me even more comfortable. All right. So, Ms. Edwards, is Ms. Stillwell waiving arraignment?
Yes, Your Honor.
We've got a form for you to fill out that you can grab off that little shelf in a minute. If you fill that out and give it to Ms. Nelson, that'll trigger a scheduling order that will give Mr. Whitenauer, who will be your counterpart in this case, to get all discovery to you. You may have a bunch of it already, I don't know, but he'll be obligated to get you the remainder of discovery by date X, whatever's in the scheduling order. You'll have a deadline for filing motions that would require a hearing pre-trial. And then the next time I will see the 2 of you will either be because we're arguing those motions, or for what I call a status conference, maybe renaming it this year, which is sort of like a final plea. I'll make sure from you have all the discovery, and then I'll see, is this resolving short of trial on that day? If it's not, it could still resolve short of trial, but after the status conference, Ms. Stillwell would not have the ability to withdraw a plea if she was unhappy with the sentence that I gave her. Okay? So we'll either see you again for motions, or you're working the case out, or trial, one of those 3 things. Mr. Rao, anything else from the state in connection with Ms. Stillwell's case?
No, Judge.
Ms. Edwards, anything else? Ms. Stillwell, do you have any questions about the process we just discussed? Okay. Make sure you continue to comply with your bond. If those conditions are proving problematic, do what you've been doing, which is fuss at Ms. Edwards, and then she'll get everyone together, and I'll see if we're going to tweak the bond again. It has been tweaked some because this case has taken a long time to get to this point. I don't expect it to go slowly now. Sometimes it takes a while to get something indicted, but once it's indicted, then you've got a judge who's pushing it along. And that's what I'll plan to do, assuming you can get all the discovery. All right, if that is it, Ms. Edwards, before you go, please, one of those forms over there is the waiver of arraignment. Please fill that out. And then I will work with Ms. Nelson to get rid of that open CP, so it's not showing in the docket that there's this unindicted murder out there. I'm less worried about what showed up on the calendar. That's a glitch. You've seen the indictment. That's what the real charges are. And I'll figure out how to fix the bond so that $40,000 amount is spread across all 4 counts.
Thank you, Your Honor.
You bet.
That concludes our business. May I be excused after I sign the waiver?
Yes, ma'am.
Thank you, Judge. Thank you.
You're welcome. And thank you, Mr. Rao, for serving as interim, what is it, supervisor?
Interim Deputy DA.
Yeah, I was wondering how many modifiers before DA are in front of it. I got
Like
the
our titles, Judge.
winter 2022 report from the madam, and there were a lot of modifiers in front of some of those names.
I did. I saw those.
Yeah. I assume those are all different pay grades.
Maybe.
No? Okay. It just makes for a longer nameplate. That could be the status symbol.
Yeah, I prefer assistant district attorney. Keep it simple.
We had one more matter on this morning's calendar. I think it's been fixed. It is Zuriel Anthony, and it was a bond modification. Zuriel Anthony has been on bond forever with an ankle monitor that Zuriel has been paying for. And the request was, could we take the ankle monitor off? And Mr. Shapiro, this is Mr. Shapiro's case, I think.
It's Mr. Whitenauer.
Mr. Whitenauer. Okay, everything is his. But there's been some paperwork flowing around. I think it's been fixed. I had a question for the DA's office, which was, I'm sorry, for the PD's office, which is, how does someone who could afford to pay for an ankle monitor as long as this guy did qualify for your office? Don't know.
Friends and family paying for it sometimes.
Okay.
And then they just say we're done.
All right. Well, I will deal with the proposed paperwork, but I thought it was Shapiro. It's Whitenauer. He's blessed it. Ms. Feely proposed it. And so we're good. And that's it for this morning. This afternoon, the motions hearing is off because it involves YSL lawyers. But we've got some status conferences. I'm trying to see. One is Mr. Johnson, Pittman. Mr. Hiles better be here. That's all I can say. Because I heard what he did. You've got one, Mr. Abate, but it's with Eric Johnson and Mr. Adams. And then Mr. Jordan, I will need you here because we're going to need to talk about that Jose Hernandez Perez. Some active defense attorneys on that one.
Absolutely.
So I'll see folks at 1, and that'll be pretty quick.
You don't have anything since that motion, but I'm gonna be in Dunaway. If you need anything.
Yeah, you don't need to be here. We know how to find you, but none of these, this was meant to be primarily an Eric Johnson calendar. Because he wasn't supposed to turn into a YSL pumpkin till next week. But things bloomed early in 2023. You bet.
Judge, I apologize, I couldn't get here sooner. I took my nephews to daycare to.
Okay, well, good for you having parental driving responsibilities. Welcome to that club every morning. And it wasn't your case anyway. Your name was on it, but it was Mr. Whitenauer's. And we got to have interim director supervisor Rao here. It was good to see him. All right, thank you, everyone. Do you know, Mr. Jordan, will you be second chairing with Ms. Ocom?
I don't believe so, Your Honor. I was going to be second chairing with Attorney Hiles if the gang murder had gone forward. I don't recall the defendant's name, but that was the only case that I was notified that I would be sitting second.
Okay. All right.
See you on Monday. Have a great weekend.
You too. Thank you.
So if the system is indicating murder, then it needs, the clerk's office needs to go in and change it to felony murder.
Yeah.
The DA needs to go in and close out the CP case.
Is that how we do it? Okay. I bet
The
Mr.
CP case that is open, I mean, it's related, but it's not related. Because they took the other CP case and.
I mean, it's related, it's the same case. It just unfortunately, so there was a CP for the ag assault and she got a bond on that. Guy dies. And then instead of using that same, and maybe you can't use the same CP number because then they said, oh, now we're charging you with murder. So then there's a second CP. Strangely, the CP case that turned into the indictment was the ag assault one, which didn't even have all the murder bonds in it. That's why if you go to the indictment, we need to talk with the clerk's office because all those entries in the open CP case need to come into our case.
Filing on the CP case.
Who?
I think they were filing their documents under the CP number.
Right, but they should have been. I mean, that was accurate because this case wasn't indicted.
But when it became the murder and they were asking for bond and changing the bond, they should have been filing under the new case.
They did. If you go to the new CP, that's where all of Glanville's orders are.
So it's not the same CP as that open CP case.
No, that's what I'm talking about, the open CP case. So there are two CP numbers. One of them, if you type it in, it just goes straight to the indictment.
Correct.
The other one has all of Glanville's orders, and that open CP needs to, I don't know if that's a DA issue or a clerk issue, but if you start with the clerk, we need that docket, that CP docket to merge into the indictment.
Okay.
Because those are all one, it needs to be closed, but those are all the bond orders that we are then turning into whatever we do here.
Okay, I'll call
Thank you.
Did you need me to communicate anything to John about that, about the CP that needs to be closed out?
Not yet.
Yeah, because I want to make sure all those documents get transferred over.
Yeah, let us start with the clerk's office, because they may say, oh, no, you can only mush one CP into an SC, and that's already happened. Just it was the wrong CP. That was a dead end CP. That ag assault was over with once that guy died, and then the new complaint for murder came. It was a whole different situation.
Understood, okay.
Mr. Jordan, who Okay, Fred, so you're logged in. I'm gonna mute you.
There we go. Should be working. Ms. Rivers, can you hear us?
Yes, I can.
Excellent. We are working. We have a status conference calendar to work through this afternoon. Our first case is two positions. It's the Salmerons. We've got Felix Salmeron. And I hope he's around because he wasn't here last time. And it'd be good if he's here.
To their office this morning, let me double check with them.
Mr. Mann, you're on mute.
I'm sorry. Your Honor, this is Frederick Mann. I'm sitting here with Mr. Salmeron in my office, and we are here.
Excellent. Thank you for being here. Mr. Shapiro, you're here. I thought you were going to be stuck somewhere else, but
I thought so as well, Judge, but
you got
made it
unstuck.
up in time. Yes.
All right. Thank you, Judge Krause. So this is the status conference, and that's what we're doing with all the cases today. Status conferences, I get an update from defense counsel, whether they have discovery, and if not, what's missing, and why haven't you let me know it was missing. We also talk about whether there's going to be a plea today, because today, if there's a plea, or any time before today, the defendant could withdraw his plea if he doesn't like the sentence he receives. After today, can certainly take a plea. It's just not something that the defendant can withdraw if he doesn't like the outcome. So we'll start with Felix Salmeron. Ruben Salmeron is probably here. His lawyer is not. His lawyer is one of the YSL lawyers, and I don't know when we'll see him again. So we have to work through what's going to happen for Ruben Salmeron Abarca, but Felix is here. So Mr. Mann, I'll start with you. What's happening with discovery?
Your Honor, we hit a little bit of a snag. The forensic evaluation of the alleged victim as to my client did not have the audio portion of the video, and I spoke to Mr. Shapiro about that this week. We were missing a special program that apparently is required for the computer to be able to play the audio with the video, but we are in agreement that we can get that disc that enables our computers to hear the audio. So I will need some time to review that, but the good news is two things. Number one, I think Mr. Shapiro and I are in agreement as to our motion to sever Felix Salmeron's case from that of his father. That's one of the three motions, if you will, that we have pending. And then the second thing is that we may actually be working towards a plea resolution, but I do need to listen to the victim's audio and complete my due diligence before we can get into some hard-boiled, specifics.
Sure. How many alleged victims are there in this case, Mr. Shapiro?
There are two alleged victims in this case, Your Honor. And with regard to the motion to sever, this may help to clarify it. We are in agreement that with respect to Mr. Ruben Salmeron's case, they are specific to one victim with the exception of one charge. However, the state doesn't believe that we have sufficient evidence to proceed on that charge.
Do you know which count that is?
I can tell you, Judge.
But that one count, whatever it is, involves the same alleged victim as Felix Salmeron's alleged victim.
Correct, Judge.
But if you're going to ultimately null pros count X from Ruben Salmeron's half of the indictment, and I'll note, at least from the calendar, none of their counts overlap. They are co-defendants on paper or in indictment, but they are not co-defendants in any of the counts. Is that also correct?
That is also correct, Judge. And I think the likely resolution for all of this, because we are in agreement that separate trials are in the best interest of the parties and the state as well. There's some issues beyond the charge that the state does not believe it can proceed on. There are other issues in the indictment. And
to Felix or Ruben or both?
As to both.
Okay.
And so the state is likely going to be re-indicting this case to have two separate indictments, one for each of the defendants. That'll resolve the issue regarding severance of those defendants.
Okay. Is it your vision, as best you can tell, that Felix Salmeron will have these same three charges, fewer, more, a worse outlook for him with the charges, or what?
These will be the same three charges.
So his situation, the only change would be he stands alone in his own indictment.
That's correct. And also that there is just some language errors in the indictment. It's
Okay. So you'll be tightening or clarifying the language. It's not adding a different victim or adding a aggravated sodomy. These three allegations refined.
Correct, Judge.
Okay. Should I not rule on the motion to sever because you are confident that things will evolve the way you described, or should I rule on the motion to sever? I don't, it would be very quick because it sounds like everyone consents to the severance. And I am anxious to let Felix Salmeron move forward because I don't know what's going to happen with his father, given representation issues.
I think we can resolve it by re-indicting it in pretty quick order, Judge.
Okay.
So I think the severance motion is just moved in.
Okay. Hold on one sec, Mr. Mann, we'll get to it. There won't be any new discovery with the new indictment.
No, Judge.
All right. And Mr. Mann now has the technology to play the audio to the victim impact interview, whatever, with a forensic interview of the alleged victim of Felix Salmeron.
I had created a hard copy to bring today, Judge, with instructions for how to access it. But what I can do is speak again to Mr. Mann. There's a way to download the program, or we can just mail him the hard copy, whatever he prefers, but we'll work with him to make sure he can access that.
Okay. Yes, Mr. Mann.
No, I was just going to ask Mr. Shapiro, since the father was charged in one count with the second degree child cruelty, I would ask if the prosecution might consider that as an additional count for purposes of whatever we do in the future as to my client. I'm not quite sure what the basis was for the father, but I see that as something that might be fruitful down the road, depending on what happens. But that's just a thought. I'm not a prosecutor anymore, so I don't have any authority to tell Mr. Shapiro's business. But that might be something that would bear fruit.
Okay, I don't have that authority either, but I like the notion of creating two separate indictments. That way they can become untethered and move at different paces. I don't intend to reset the clock with the re-indictment. What I will do, here's my proposal, is that we're going to move Felix Salmeron's case, his part of the case ending in 526, to a trial calendar. I'm going to preserve his final plea rights because, Mr. Mann, you haven't had a chance to get through that forensic interview. And it could be something that shifts your negotiating posture. And after you hear it, you may be ready to push real hard, Mr. Shapiro, to reach you where you are, or the flip side may be that you realize you need to come up a little bit based on the impact of that forensic interview. Regardless, you need to watch it and process it, and importantly, discuss it with your client. When there is the re-indictment, it will go on to the trial calendar. We'll have to have an arraignment. We'll do that. So it technically might pop up on a plea and arraignment calendar, but that's only for the technical requirement of arraigning Mr. Salmeron on the new case. And I would hope Mr. Mann would execute a waiver of arraignment and we wouldn't even need to drag folks virtually or physically into court for the arraignment, assuming it's the same three charges with just the language tightened up. And then that would replace the 526 case on whatever trial calendar it's on. It's time for Felix Salmeron to get closure one way or the other. So that's my proposal. Mr. Mann, just for your scheduling purposes, that's not a calendar that would be until March, April, something like that. It's not next week. It's not early February.
That's very helpful, Judge, because Mr. Shapiro and I seem to communicate very well. I'm happy that he's on the case. Not suggesting any type of resolution, but I just I find it easy to talk to him. So we will try to work this case out. If for some reason we cannot, I will use the intervening time between now and trial to have a private investigator working with me, and we're meeting with them today. But I'm hopeful that we don't have to go that route, that we can actually resolve the case.
Okay. Mr. Mann, I'm curious, and you may say I can't comment on it, and I'll respect that answer. You're retained by the Salmeron family. I don't know if it's because Felix had a lot of money in his pocket, or the family did. His father has the conflict defender, who is unfortunately involved with this large gang case and is not going to be available for potentially many months. Do I need to engage with Ruben Salmeron to see if there are resources for the family to obtain a lawyer? Do you have any insight into that, or is that an area you don't even want to talk about?
No, I don't think there's been any misrepresentation about financial status. The reason is my client's mother and Mr. Ruben Salmeron are separated. They are divorced, and his mother has been the benefactor here to help him.
Got it. Okay, then makes sense. And I'll need to work with Mr. Johnson, the attorney for Mr. Salmeron, to see how we'll keep his case moving forward, because of course he's stuck in jail and these delays are even more painful for him than they would be for your client. All right, I think we've got a plan. Mr. Mann, your obligation is to let Mr. Shapiro know ASAP if you cannot get that audio to work. Because what I don't want to do is bring everyone together again in 4 weeks or whenever it would be, and then you tell me, gosh, I still haven't been able to listen to that thing. Well before then, you're raising your hand to me, to Ms. Nelson, to whomever, so we could say, make this happen. Okay?
Yes, I would just ask Mr. Shapiro if he doesn't mind, just because it's tough for me to come downtown and pick something up. If he could just send it to me in the mail, that would be great.
And that's fine, Judge. There is one more issue, though, that the state wanted to raise. The state's filed an expert notice as well as a child hearsay notice. Mr. Mann, for his client, filed some responses that I believe they're cased as response and objections to the state's expert notice and the state's child hearsay notice. There are some aspects of that response that look like potentially a Daubert challenge or a motion to pierce rape shield. I should have discussed this with Mr. Mann yesterday. It slipped my mind, but to the extent that we do need to be placed on a motions calendar to argue those motions, if they are substantive motions to exclude or to challenge our expert, the state's just asking for a more particularized motion, and then we'll have the case placed on a motions calendar if we need to.
Your expert would be someone who knows the facts and circumstances of this case, or is more of what I've called an educational expert who would help a jury understand how victims of sexual assaults process, react to the events, to reporting, to outcry, to testifying, or is it the actual forensic interviewer?
It's the actual forensic interviewer, Judge. And so we've obviously noticed her as an expert. She could speak to all those other aspects as well, but she was also directly involved in interviewing the victim. In this case.
And did you notice her as an expert in the field of forensic interviewing so you can defend her technique, or did you notice her as an educational expert, but she would happen to also know something specific about this case because she interviewed the alleged victim?
Again, Judge, it's the notice is that she's an expert in the field of forensic interviewing. She's familiar with child sexual abuse, including interviewing victims, child sexual abuse, outcry. However, she was, again, just the forensic interviewer for this victim. So again, it's a little bit of both.
Okay, got it. So Mr. Mann, you may out of an abundance of caution have filed those responses, but I need you to help me understand, you didn't want to waive anything, so you filed those, or were you actually fashioning those in such a way, maybe it wasn't as clear as you had intended, that we need to have a Daubert hearing as to the admissibility of this expert and her testimony?
Well, it was actually as to the giving of any type of opinion testimony by the forensic interviewer of the victim in Felix Salmeron's case, because essentially our position is that would usurp the province of the jury, and any kind of comment on veracity or credibility is not appropriate for her. And then I also questioned her credentials. I'm not quite sure what level degree she has, but her report is essentially, a bolstering, if you will, of the state's case by saying that she felt the victim was being forthcoming and essentially just offering an ongoing opinion based on answers to questions in the evaluation. I understand there's a hearsay exception for her to say what was said by the victim to her, but any type of commentary or opinion about the veracity, credibility, whether or not that's consistent with someone who's been the victim of child abuse, I just don't think that's appropriate for her. She's not a medical doctor and she's not a psychiatrist.
Well, until the very last thing you said, I was agreeing with you. And I don't know that Mr. Shapiro would, I don't believe he ought to try to elicit testimony from an expert as to the credibility, believability, or veracity of the alleged victim's statement. That hasn't changed because of the change in Chapter 7 of Title 24. That remains the law, as you said. Where I part ways with you, and we may need to have a hearing about it, is the notion that an expert could not say that something is consistent with. That happens all the time, and I have ruled on that and been upheld by the Georgia Supreme Court multiple times that experts can say, in my experience, and this is assuming there's an experiential base for saying that, and that's part of your argument, but if one assumes for a moment that this individual has interviewed 500 people, children who were the alleged victims of sexual abuse, I think she is in the perfect position to tell a jury who doesn't know otherwise that to not cry during an interview is not inconsistent with having been the victim of sexual assault. Or the reverse, to cry during an interview and shut down. That's where these become, as I call them, educational experts, and the case law is very strong in support of allowing that in. It is equally strong, if not stronger, that these experts cannot go to the ultimate issue of, well, do you think this person was abused? Or should we believe this person? So I'm agreeing with 2 out of the 3 things you're saying, and it may be we need to have a hearing on it. It sounds like it could be a pretrial hearing because it wouldn't be full-blown Daubert. It would be basic credentials of this individual, and then just clarifying, and I'd have the case law available if we need it, no to questions about credibility, believability, ultimate issue, but yes to questions about, was this consistent with your experience, that kind of things. I just,
if I may, Judge, my concern was that Ms. Pa, I think is how she pronounces her name, PAA, was being called, according to the pleading from the state, as I understood it, to give opinions as an expert, quote, in the field of forensic interviewing and child sexual abuse, including the process and technique of forensic interviewing, disclosures of sexual abuse, issues of memory, recall, coaching, and recantation, and instances of grooming and manipulation. That last language in particular to me was very offensive because, she's basically going to line up and say that this is the classic case, somebody who has been groomed, and her interview with me fit all the parameters of someone who had been groomed and manipulated and so on and so forth. And to me, that's a distinction without a difference between offering an opinion about the credibility of the victim.
Okay. Well, I think, again, that's something we could handle with a motion in limine. Certainly, we would need to discuss this, one, before trial started, and definitely before this individual was called. So I better understand your concern now, Mr. Mann, and it merits discussion and some ruling from me before the trial begins. I don't know that we need a full-blown Daubert hearing based on what I understand Mr. Shapiro would intend to do with this witness, and then your concerns about that. So let's table it for now. And I will enter an order that severs the two, which will then be mooted by the reindictment that will have Felix Salmeron in one case and Ruben Salmeron Abarca in another. Anything else from the state?
Nothing from the state, Judge.
You'll put in the mail the magic software that will allow Mr. Mann to listen to the forensic interview.
Yes, Judge.
Mr. Mann, anything else on behalf of Felix Salmeron?
No, Judge, like I said, I'll be continuing to talk to Mr. Shapiro, and I'm hoping that he might be available this afternoon. Actually, I've got some information that he may find.
Great. How old is your client, Mr. Mann?
At this time, he's 22, Judge.
And if we go forward with a trial or we take a plea, anything substantive, does your client require an interpreter?
He does.
He does. Okay. We'll make a note of that.
He speaks enough English to understand what we're doing here today, and I somehow became bilingual, majoring in Spanish and going to school abroad, so I translate and speak to him in Spanish.
Sure, but for something official like a plea or a trial, we'll need to make sure that there are interpretive services available for your client.
Absolutely. Yes, sir.
Got it. We'll take care of it. Thank you, sir. You're free to go.
Thank you, Judge. You have a good day.
Oh, can you, one last thing? Oh, you still there, Mr. Mann?
Yes, I am, Judge.
Can you ask your client if he knows if his father requires an interpreter?
Yes, he does not speak English.
Okay, thank you.
Thank you, Judge. Thank you, Mr. Shapiro.
So I can't really help Ruben Salmeron out today.
It's,
I didn't think he was transferred.
Oh, great. Well, then I don't need to worry
I
about it.
think so.
Okay. Do you know, is Mr. Salmeron one of the people who's up here?
Yes.
Okay. All right. You don't need to get him. We don't have a way of communicating with him. Ms. Roberts, do you have a case number? No? Okay. I'm going to have Ms. Nelson look this up. We'll give this back to you. But I don't have a trial calendar today. Why don't you take a seat and we'll figure out what's going on, okay? Never seen something like that before. Mr. Shapiro, if the stars aligned and you weren't pulled in lots of different directions, how soon would this be reindicted?
I would need to look at the grand jury schedule, Judge, but I anticipate that we could get this done, I mean, within the next 2 weeks.
Okay. I'm not rushing, because like I said, I'll sever them. We're moving Felix to a trial calendar, but that's in March-ish. So you'll have I just want to make sure you weren't, I'm not going to get to them until April.
No, Judge, I don't think it'll take that long.
Position 3 is Antonio Sanders, and that is Mr. Hoover, or was Mr. Hoover.
Mr. Hoover, I think we're holding for his report.
We're holding. Okay, Mr. Sanders has 2 cases. Mr. Jordan, you got the tough one, theft by receiving. And then we've got the one with Mr. Sanders, again, with Mr. Hoover, and then Mr. Johnson. Do you know, by any chance, Mr. Hiles, why there's not a public defender on either of Sanders or Pittman?
I don't off the top of my head. I think I can think there were multiple I guess there were co-defendants in other cases that didn't make it here beforehand. Some of their other alleged gang members have been represented by the public defender. But off the top of my head.
It's okay. I just was curious because I'm just looking for a solution to get Pittman moving along, because all your good efforts are going to stall until either Mr. Johnson resurfaces or I'm in discussions with GPDC about backfilling for him on some cases. And I just need to prioritize how we do that.
Yes. I do. I'll research it a little more, but yeah, anything to keep it moving. But
okay, but we're adding a defendant anyway. So why don't you bring me? There are no lawyers here on the defense side. Oh, but Mr. Hoover is we think he's going to join us?
Yes.
Okay, so we're going to table this. Other than tell me what happened. There's a new indictment It keeps Sanders and Pittman. There's a new indictment for 8773.
Yes.
And it's
Well,
now,
actually,
no,
so Your Honor, it's not a new indictment.
it's a different indictment.
It's a different indictment. It's
It's
actually
an old indictment. It's not an old indictment.
No, it's a brand new indictment.
Okay, so it's new.
Yeah, it's brand new. We knew about Antonio Sanders' alleged involvement in other crimes for a long time. However, I wasn't satisfied with the investigation in bringing a new indictment and or even filing for 404Bs. So over the past 6 months, College Park, East Point, City of Atlanta all got together. And there was multiple armed robberies, attempted entering autos where individuals were shot when they were interrupted, much in line with this case. So that was, and I don't think Mr. Chapman, who is the co-defendant of Antonio Sanders, was involved in the murder in any way. And it was.
Oh, so the new case ends in 4 2s, I believe.
Yeah.
No. It ends in 5558. I'm trying to understand the notes here. Regardless, there's a new indictment that you brought that's a gang indictment, but it is it also Pittman or is it just Sanders and Chapman?
It's just Sanders and Chapman.
Okay, so it is not a re-indictment of this. Mr. Sanders is a busy young guy. He's got his whopping theft by receiving case with Mr. Jordan. He's got this murder with you, and now he's got yet another case that is a whole bunch of armed robberies.
There is an armed robbery and then several ag assaults, theft by takings,
Okay.
entering autos.
Only one armed robbery. Okay, I just thought you said it was a bunch of he shoots people when it gets interrupted.
There was entering autos where.
Those were interrupted.
Yes.
Okay. But none of those offenses overlaps with the murder we've got here, 773. It's brand new stuff.
It's the same time period. But it did not, I just elected not to re-indict the murder and put 30 people at the table for that one.
Okay. So we've got Sanders and Pittman.
I see Mr. Hoover on.
Great. Hello, Mr. Hoover.
Hello, Your Honor. I apologize for my lateness. I've been all over the state today.
No doubt. No worries. I was just being brought up to speed a little bit by Mr. Hiles. Where are you today?
I left Troup County. I am now in Fayette, and then I'm heading to Spalding after this.
Well, right now you're in Fulton. Enjoy it. The air is fresh here. Let me look up one case number here so I know I'm not giving you bad information.
Okay. And on the new case, a private attorney has made an entry of appearance.
For Mr. Sanders. And is that Marcia Mignot?
Yes.
I may be butchering her name.
I didn't say that for a reason.
Okay. If she's French, that's how I would say it. That case is assigned to Judge Schwall only because he hasn't figured out yet that it's coming to us. If you want to quickly resolve the Sanders murder case.
I spoke with Ms. Wood yesterday after I spoke with Ms. Nelson, and I'm surprised she has not.
Okay, it's fine. It's coming here. But, and is John Dixon, is that a private attorney? Or is that a public defender? That's Chapman's lawyer.
I don't know. I don't know.
Okay, so stick with us, Mr. Hoover. You may have dodged another case. But then we'll just need to understand what's happening here.
Yes, Your Honor.
Yeah, John Dixon is a lawyer from Chattanooga. I don't think you have enough counts in the indictment. It's a re-indictment. I don't understand that.
So Jaden Chapman was originally charged in a 22 SC indictment was a theft by receiving that was incorporated into this.
So can we null pros 22 SC 182222? That's what this is a reindictment of.
Yes, absolutely.
All right, Ms. Nelson will take care of that. That just removes one case number floating around out there.
There's no process. We only, instead of bringing it over, I guess, from, because it was a non-complex.
It was coming to us anyway, but now it can go to bed. I wonder if this guy was just in for bond. So is Chapman in custody?
Yes.
All right, we'll need to figure out who his lawyer is. All right, I'm sorry, Mr. Hoover. So we are here today for you, for Mr. Sanders, your client. You've got two cases with him. There's a theft by receiving, and then really the reason why you're involved, there's a gang murder case. Mr. Sanders has a co-defendant, gentleman named Mr. Pittman. His lawyer is one of the lawyers who has been absorbed by the YSL case, so we can't work with Mr. Pittman today. What I was working through with Mr. Hiles, who is your worthy adversary in the gang murder matter, is that Mr. Sanders has a new indictment with many counts, no murders, but some gunplay, ag assaults, and armed robbery, et cetera. He's got a co-defendant in that, but more germane to you, Mr. Sanders has a retained attorney in that case, which is confusing to me because he's benefiting from your services in the murder. So we may need to, we meaning my litigation manager and I may need to reach out to the lawyer who purports to be Mr. Sanders's lawyer in this new case to figure out if the source of funds that brought her on board is available for your cases as well. You are pulled in lots of directions. And it, regardless of how busy you are, it's just much more complicated to have two different lawyers across the cases.
Who is the?
It is Marcia, and the last name is spelled M-I-G-N-O-T-T, Mignot or Mignot.
Okay.
And she filed her entry 3 days ago. So it's fresh, 2 days ago, according to the clerk's stamp. She's a lawyer out of Tucker, Georgia. So we're going to reach out to her. She represents Mr. Sanders in this new case that's not on the calendar, and we don't need to get into it other than the fact that he seems to have a private attorney. Why don't you tell me where you are in terms of your getting discovery and wrapping your arms around the murder case of Mr. Sanders? Because that's really what we were going to do today. And then the state threw this little curveball at us of that, well, you know, actually a new big indictment for Mr. Sanders as well. And it's not Mr. Hoover's case. This other person has grabbed it.
So I believe I have all of the discovery, and it's the process. There's a lot of it, and we're just going over it all. Mr. Sanders and I have discussed what we've gone over so far, but there are certain interviews and statements that he and I still need to talk about. But we are proceeding. If I'm staying on the case, we're in good shape right now.
Okay. And to date, all the discovery that you have messed with works, meaning the videos play, the audio works.
Yes, it was tricky at first, but now we figured it out. So yes, it all works.
Okay. And is Mr. Sanders in the county jail? Is he in the state system?
Well, he was in the county jail, but I'm not sure if this new case did something about that. But last I spoke with him, he was still at Rice Street.
It won't. He'll still be at Rice. It shouldn't make a move. Oh,
I thought last time we were.
No, Douglasville, you're right.
No,
he.
Mr. Hiles thinks he may be in the Department of Corrections custody. I wasn't quizzing you. I don't know where he is. I was asking more so in terms of your ability to meet with him. Where is home base for you?
Atlanta.
Okay. All
The
right.
judge, remember, he was in DOC, but then he's being housed in Douglasville right now. That's where I keep seeing him.
All right, good. I mean, that's closer than Waycross. All right, so he is local-ish. You've got all discovery and you're doing what you can to connect with him and get up to speed with him on things. We'll need to work out representation in light of the new case and the private counsel. Mr. Hiles, if we were to fast forward 6 months and I'm now saying we got to do something with Mr. Sanders, which case are you going out on? Are you going out on the murder case or I call it the new case, it's the newer indictment. I understand it's contemporaneous conduct, but which you'd actually get to pick, which would you go out on?
The murder.
The murder. Okay. If Mr. Pittman can't be ready because his lawyer remains stuck in 8F until 2028, do we sever or do we then do the other Mr. Sanders case? I hadn't thought about that.
Let me
Get back to me.
let me get back to you on that.
Okay.
More than likely the murder, but I don't want to commit to that.
You're not, well, none of this is committing to anything. Mr. Hoover has said, look, I'll be ready when it's trial time, which is not this week. But Pittman can't be ready by that time. Not Mr. Sanders' problem. And so if we reach a point that we need to, I feel like we need to move Mr. Sanders forward, then you will be at that crossroads of either we go forward on the newer indictment or we have to sever Sanders and Pittman. I don't know anything about that case. You may be then trying the getaway driver and Pittman was the one who shot someone 100 times. And it's not usually great to try the getaway driver. But just be thinking through that because it's not inconceivable that we would hit that fork in the road where we're trying Sanders and Chapman,
Right.
or we're trying Sanders all by himself in the murder case.
That'll get it. Yeah.
Again, don't need to decide now, but you need to be thinking about that.
Understood.
Or we try the theft by receiving. All right. Mr. Hoover, do you need anything else other than a clone?
No, Your Honor, that's it.
All right. What I'm going to do is figure out with Ms. Mignot whether she is in only for the newer indictment or if there's some possibility that she would be filing an entry in the murder case, especially given Mr. Hiles's announcement that he'd prefer to do the murder trial first. We'll let you know either way, because if you're off, then you're off. An entry will let you know that. But if you're on, then I'm going to want you to continue to approach that trial ready status because we also might see if we can find a replacement for Mr. Pittman so that the murder could be tried without a severance. Mr. Hiles, do you remember enough about the Pittman Sanders murder case to know that there's no mandatory severance or no Bruton issues? Because it would be frustrating. You get to trial and then you say, oh, well, we should have severed them anyway.
There's no Bruton issues.
Okay.
in this particular
So in a
case.
perfect world, they could be tried together, each with his own lawyer.
Yes, and I will be, Mr. Hoover, providing all of this new discovery from his new indictment to you regardless of whether, because it is relevant to this case,
It's what you would contend is 404B.
or 418 as well.
Oh, right. Oh, good old 418. Okay. I don't see that a lot. Okay. Mr. Hoover, anything else from you on behalf of Mr. Sanders?
No, Your Honor.
Okay. Well, I appreciate you joining us from wherever it was you said you were. You can resume safely driving.
All right. Thank you, Judge.
Mr. Hoover.
Hold on one second.
Mr. Hoover,
Yes.
I think you're off the hook. All the discovery I gave you for the probation revocation. Mr. Adams filed an entry on Andre Hill for that.
Oh, okay.
So,
When did he file that entry?
yesterday.
Okay. I'll make sure I get out of it.
Yeah, get out while you can. All right. Have a great weekend.
All right. Thank you, Judge.
So in terms of Mr. Pittman, you've provided discovery, Mr. Hiles, and you're ready to go on that. And this new indictment that's bringing us Mr. Chapman, I don't have anything to do with Mr. Pittman. I mean, his name's not in there. Maybe he'd be a witness in it, but he's not a defendant in that case. The Chapman Sanders situation doesn't slow Mr. Pittman down in any way.
No.
Okay.
I mean, he'll be getting that discovery too. It's
Sure.
all part and parcel to the gang and the existence of the gang.
Got it. What Mr. Pittman needs is a lawyer. Okay. All right. Excellent. Appreciate it. Let's turn then to Emmanuel Watson and Ms. Scott. Is Ms. Scott here?
Your Honor, may I be excused, please?
You may. Hey, Mr. Adams. How are you, sir?
Doing fine.
Any idea where your client is?
She should be on the line. I talked to her earlier. She gave it a Zoom link, so she should be on it.
Okay, why don't you reach out to her and we'll take the next position on the calendar, Mr. Perez, and then we'll see if we can get Ms. Scott here so we don't have to do anything with her bond, okay?
Okay, can I cut off and come back?
Yep.
Okay, thank you.
Sure. And you can finish your lunch. Oh, yeah, sorry. All right, Jose Hernandez Perez, sir, if you come up to the table. Mr. DiTardo, does your client need an interpreter?
Yes, Judge.
Letting us know that in advance is a helpful thing.
I'm sorry, Judge. That's my mistake. I apologize.
We will reach out for one. I can't guarantee that we'll get one here, but we are talking about procedural things. So the important part is that you're able to follow it, and we'll see if Mr. Perez is able to get caught up if we get an interpreter in here during the course of the conference.
Okay.
So you weren't here for me, you were here for Mr. Hiles?
I'm here for you.
Oh, there are no more cases on the calendar.
The Edge Corvus Hall was also.
Oh, that bond, right.
I almost forgot about it too.
Good, we'll talk about it. Yeah, I forgot about it. Good thing she showed up. Okay, so let me grab the paperwork I had in the Hernandez Perez case. So Mr. DiTardo, help me understand what you are still missing from discovery. I know one holdup on this has been something that you weren't able to get, or it wasn't openable, or what?
So I was previously dealing with Mr. Hand prior to his departure. He had provided me discovery a little late. I guess he didn't realize that it hadn't been sent, but he sent what he had. And there were some items that I identified as potentially missing. And then, of course, Mr. Hand has departed. Mr. Jordan has taken over his caseload from what I understand. And so Mr. Jordan was working on those things for me very diligently, in addition to doing the dozen other things I'm sure he had going on with moving over there. So now we're finally at a point where Mr. Jordan has told me that I have everything that he has. There are a few things just from, my familiarity with these types of cases that seemed odd to me that they were missing. But Mr. Jordan has represented to me that he's given me everything that he's had. He's checked with law enforcement, and they've told him this is what we have, and we don't have certain things that are missing. So if I could just kind of briefly outline what I'm referring to, if the court's interested in that.
Yeah, no, I am interested. Hold on one second. Mr. Abate, if you're here for Mr. Watson, my thought was just to bring him to the door to let him know why we brought him over here. You're welcome to stay for that, but we can't do anything substantive. Oh, but you're also here for Ms. Scott. All right, so you're here. All right. It's your indictment. I'm sorry, Mr. DiTardo. It would help me to understand what it is that you have good faith suspicion, like, hey, why would this not be in here?
Sure. And so this case is essentially a case that involved an informant giving Sandy Springs Police Department a tip that there was an individual that was trafficking methamphetamine in the Northwood Drive area. Officer Reynolds with the Sandy Springs Police Department seemed as if he was sort of heading things up. There was a separate officer, Canine Officer Cabrera, who actually effectuates the traffic stop on my client, and then has the subsequent interaction with him, runs his drug dog around my client's vehicle, and ultimately conducts the search of his vehicle, which yielded the methamphetamine in question that serves as the basis of the one count of the indictment. So I know that it's not unheard of that sometimes officers don't write reports on things, but Officer Cabrera's report was not included in what I was given. It was simply Officer Reynolds' report, who entirely references Officer Cabrera's involvement. Nothing from Officer Cabrera in writing at all. So that was one item that I identified as missing that I've been told doesn't exist. Okay. There was also some body worn camera footage that was provided. We do have, fortunately, body worn camera footage from that officer, from Officer Cabrera. We have his patrol cam video. And then we had body worn camera from two officers that responded to back up Officer Cabrera. That's the entirety of the that's the entirety of the video footage that we have. Unfortunately, Officer Reynolds' report references some subsequent interactions and eventually an interview that was conducted with my client. And we have no video of that. So one of the things that I inquired with the state was, is there some video of this interview, either body worn camera or in an interrogation room or whatever? Apparently that doesn't exist.
Is there audio of the interview, or there's only Reynolds's write-up of the interview?
Only Reynolds' write-up of the interview.
And this agency was Sandy Springs?
Yes, Judge.
Okay, hold on one second. An interpreter has parachuted in. I don't need to swear you in, Mr. Lars. If you wouldn't mind helping Mr. Hernandez Perez, I'll give you a moment to introduce yourself. We're having a status conference, so we're just talking procedurally about what's going on. So I won't be asking Mr. Hernandez Perez any questions other than at the end, does he have any questions?
El juez quiere que lo asista con traducción. El juez está indicándome a mí que este es un proceso ahorita, esta etapa, que están hablando sobre la condición.
Good, I've got three we need to make. Well, one of them you have, Ruben has, but we need to add to Felix Salmeron, and then definitely to Mr. Hernandez Perez.
Okay, él te dirá, okay? Entonces, ¿te asisto yo? Okay. All right, Judge, I have to.
Great, thank you so much for being here. Okay, so no recording of the interview.
No recording of the interview. There was also a search of my client's residence that he put in that for. Nothing was found, but I have no sort of body worn camera from any of the officers that.
Hold
on one second. Mr. Lars, do you mind if you turn that microphone off? That will help.
Thank you.
There you go. Whoop.
I got it.
Nope. Just once. Just then take your thumb off.
Got it.
Nope. Just then take your thumb out. You leave it on too long. Just tap it.
Oh, okay.
There. Excellent. No, it's all good. It was picking up your important conversation and making it a little fuzzy. All right. So I lost you for a minute because the sound was going in and out. I get it. No recording of the interview. What was the thing after that? Oh, the search of his house?
Search of his apartment. Nothing, no contraband was found, but my client, per Officer Reynolds' report, gave consent for that search. Nothing was found, but I would assume that some video of that would exist, but that's not anything that we were given. And then the other thing that was missing, there's a reference in one of the officers' reports, a supplemental, that my client's cell phone was taken, that a search warrant was obtained, and that cell phone was It seemed to be either the beginning of the extraction process was going on. It wasn't clear from the report, but it seemed like maybe there would be some evidence of a cell phone extraction and certainly a copy of the search warrant. Don't have any of those items.
Okay. So I've got no report from Canine Officer Cabrera, no recording of the interview. Was it a custodial interview, or that's something that needs to be argued about, or it was pretty clearly he's in handcuffs and can't go?
I think it's very clear that it's written in the report, he was arrested, and then subsequent to that, those conversations occurred. Although one of them, it doesn't reference anything about Miranda. The other one, it says that he was read Miranda in Spanish.
Okay. No video of the search of the apartment, but the information you've received, this is a consent-based search. So it's not that there's no warrant. It's just that there's no video of the search, although nothing was found there. And then finally, what's the deal with the cell phone extraction?
I don't have a cell phone extraction, and I don't have a copy of the search warrant if it exists.
Okay. And as far as you know, your client did not give consent to search the phone.
Correct. And in the report, in one of the supplementals, I don't know if it was from Officer Reynolds or a different officer, but it references that there was a search warrant obtained and that the phone was passed on to whichever officer it was over there that handles their extractions.
Mr. Jordan, this case has been bedeviled by discovery issues before your time, but you're in charge now. Let's take them one at a time. Officer Cabrera report. Sometimes if you're not the lead officer, you just tell the other officer, here's what happened. Is that this case?
Your Honor, I believe so. And this answer may be an all-covering answer as far as the issues, because I was aware of Attorney DeTardo and I have exchanged emails since I've been in the courtroom. I did reach out to Detective Villagomez, whom was over the case, and he has assured me that we have everything that Sandy Springs currently has. I know we discussed the interview. He said that there was no interview that was located in his file. Meaning
there's no recording of the interview. Apparently there's info about the interview in the file, but there's no recording.
That's correct, Your Honor. So as far as everything that Attorney DeTardo says, I agree with that. I reached out to Detective Villagomez right before the holidays and harassed him until he finally gave me the answer. And as soon as I got that information, I forwarded it to Attorney DeTardo saying that nothing else was coming, unfortunately. So just an all sweeping answer. He is correct that we are missing those items. We've reached out for those items, but apparently Sandy Springs does not have any of those items.
Well, you're not missing them if they don't exist. And so, for example, it may well be they did not record the interview of Mr. Hernandez.
Correct.
Odd choice in this day and age, but if it wasn't recorded, it's not missing. It does sound like there are documents that you've got, Mr. Jordan, that reference a search warrant for the phone. And so for you not to have a search warrant from Sandy Springs that's referenced in their report is sort of a you problem.
And I may have lost that in the shuffle because when 88 Hand departed, he sent me the entire email chain between Attorney DeTardo and himself. I was only aware of the interview that was missing and also the canine issue, but I wasn't aware of the search warrant for the phone issue.
Okay. Well, you can look into that. Where are we in terms of things we can work through, Mr. DeTardo? You filed a motion to quash that was pretty generic and didn't seem really applicable. I don't know if that's just standard. It was actually Mr. Sonoda who did it. If that's just standard practice, I've got a new client, so I'm going to quash the indictment, but there was nothing of substance in it. There was a motion for a Daubert hearing. I'm not sure for what. And then you had a motion to disclose favorable evidence, which I grant. That's the law. And there we were. So I can understand why you haven't been able to particularize a motion to suppress statements because you're not sure, wait a minute, is there a recording of the interview or not? And why you're not in a position quite yet, other than to say, you got to suppress anything from the phone because I don't have what they got from the phone. And they say there's a warrant and I don't have that. But what, I guess I've laid out what I think we've got. Are you withdrawing the motion to quash?
Yes, Judge, we are withdrawing the motion to quash the indictment, the demur essentially. And the reason why I file all those boilerplate motions is because unfortunately, although we always file a motion asking the court to allow us additional time to file any motions, there are some jurisdictions, unfortunately, where the judges don't rule on those motions. And then when we identify an issue, they say, oh, too late, it's past the 10 days.
Okay. All right. Well, that's not here. The motion for Daubert hearing right now, I'm going to deny as moot because it's not clear to me what you'd be trying to keep out with that. That doesn't mean it couldn't change. So what are the next steps? I think one is that Mr. Jordan's going to need to connect with his best friend at Sandy Springs Police to ask about the cell phone extraction and search warrant and what was done with the search of the apartment, because I didn't hear you mention that either. In other words, is there any video of the search of the apartment?
He did, Your Honor, detective did say that there were no further body cam that they had. So I think that's a pretty sufficient answer.
Okay,
to that.
so we could cabinet to cell phone, extraction thereof, and the search warrant that would have authorized that.
Yes, Your Honor.
And you'll reinitiate communication with that detective.
Yes, Your Honor.
Okay. All right. So I think right now, Mr. DiTardo, we all move forward with the notion that there's no Cabrera report and no recording of the interview. If that changes on the eve of trial or in the middle of trial, mistrial, suppression, I mean, all sorts of bad things could flow in the direction of the state. But Mr. Jordan has done what he can. And I think he's made that good faith effort that I need to hear about to say, all right, we go forward under the assumption, no Cabrera report, no audio or video recording of your client's interview, and no video of the search of the apartment. And that's the posture we're in. I'm happy to table the cell phone for a couple weeks while we learn more.
And that's fine, Judge. I did want to mention, assuming that what Mr. Jordan had communicated to me was true, out of an abundance of caution, I actually did file a particularized motion to suppress 2 days ago. I think it was late on the 4th.
Okay.
So it sounds like, at least as far as that's concerned, we're ready to go forward on that hearing whenever the court feels it would be appropriate. It's a motion to suppress evidence and statements.
What's the evidence? Meaning what was found in the car?
Yes, Judge, the drugs.
Okay. Well, why don't we do this then? We'll calendar that, but it will be far enough out because I've got some trials coming up that there'll be more than enough time for Mr. Jordan to either be told, oh, no, there's no cell phone, or get you the extraction, the warrant behind it. And it may be that there was nothing of value on the phone, but that doesn't mean there's nothing of value to the defense. So you're entitled to what was on the phone and the warrant that authorized them to extract it if they went forward with the extraction. But that motions hearing will be far enough in advance that I would ask you to weave into it any suppression concerns you've got about the phone.
Okay.
All right.
So that would not be on that. I think you had a February 6th date. That wouldn't be when we'd have it.
Oh, nope. I'm not saying that. If that was the date, let me look that up. I don't get crossways with my scheduler.
I also see a February 6th status conference date, Your Honor, and a February 27th trial date.
Okay. Well, I'm going to look myself. Just Odyssey's being slow. Whoops. That wouldn't be the right indictment either. It's Mr. Chapman. Why are you still here, Mr. Hiles? Oh, that bond motion.
I know you don't want to look at me.
Well, it's really the mustache, but we'll pretend it's the indictment.
And Your Honor, while you're looking that up, I was in receipt of Attorney DeTardo's particularized motion to suppress, so the state will be ready for that whenever the.
Good. No, I see it, and it won't be either. Obviously, it won't be on the trial date. There will be another date. The motion to suppress came in a little late, and so whatever motions date we might have built in for this case has already passed. You haven't waived anything. All those dates will change. So there will not be a status conference in this case on the 6th of February. We have that after we've worked through the motion. And then obviously that trial date will change as well. So stay tuned for a motions date, just so we can plan it. How long do you've read the motion to suppress now, Mr. Jordan. So how long do you think the hearing would be? Is it one officer? Is it, if it's the search of the car, it sounds like that's Cabrera. And I don't know if Reynolds was there for the search.
Your Honor, at least from my initial reading of it, I believe it would only be a maximum of 3 witnesses.
And that will cover the statement also.
Yes, Your Honor.
Who obtained the statement?
Your Honor, I believe it may have been Detective Villagomez, but his name is just in my head, of course.
Okay,
because of
but you think 3 witnesses would cover search of car as well as statement?
Yes, Your Honor.
And then we may augment that with how'd you get the phone, and well, I assume they got the phone when they arrested Mr. Hernandez, but how'd you get into the phone? But that's a search warrant.
That's correct.
Okay. All right. So an hour, hour and a half, how long do you think that hearing will go?
I would say no longer than an hour and a half, Your Honor.
Okay. All right. We'll book 2 just to be safe. So Mr. DeTardo, we'll look for a 2-hour window somewhere in the near future. It will not be the month of January. For the suppression hearing in Mr. Hernandez's case. Your job, other than to protect that time once you get the calendar, will be to supplement your motion to suppress when you learn more from Mr. Jordan about what happened with the phone.
All right, sounds good.
All right, so I will deny the motion to quash because you withdrew it, or we'll handle it somewhere. Just take care of that. The motion for a Daubert hearing is moot for now. And then we'll put the motion to suppress on a docket coming up soon.
All right. Thank you so much, Judge.
You bet. I'm going to ask your client if he has any questions. Sure. Hello, Mr. Hernandez.
I'm well.
Good. Do you have any questions about what we discussed?
No, it's fine.
Okay. We will have an interpreter here next time you're here.
Yes, very well.
Excellent. Mr. Jordan, anything else?
Nothing further from the state, Your Honor.
All right. Thank you, Mr. DeTardo, for joining us. We'll see you probably down here for the suppression hearing.
Yes, sir. Thank you.
All right. Finito.
He's asking for a copy of everything that we did today. Do I get a copy?
So we didn't do anything that gets put on paper. But if he has questions, he should call Mr. DeTardo. Great, thank you. All right. Mr. Elias, thank you for coming in without notice. We've made a note in Mr. Hernandez's file that when he's on the calendar in the future, we'll book your services or the services of a colleague. I'm curious, I had to sign a form recently to get you reimbursed. I thought we were all done with that. You dropped it off.
Yeah, well, that was actually work.
Oh.
Just before I got hired, I appeared on 2 different days that you saw late in the afternoon for Orca.
Okay.
And I forgot about it. I was reading my desk and I found it.
There it was.
I checked.
Okay.
And, I actually, they owe me that. Judge, can I just tell you one thing here?
Sure, if it's real quick.
I don't know if it's important, but I think it should.
Shackle.
Exactly. That's already being discussed, that how are we doing this all over again?
So I was asked to actually leave the area.
Okay.
And, but I think, you know, we have a lot of people in the JRC. that-
We do. It's a volatile situation.
Very delicate.
Okay. Thank you, sir.
I'll let you know.
No, I appreciate that.
Yeah, is there any way we can handle this, Mr. Hall, so that I can report back to Judge Landau?
Oh, he's waiting on you?
No, I'm waiting.
Oh, okay.
They're still in.
Yes, let me, if Ms., we'll do that right after Ms. Scott, and then we'll do that. Ms. Scott, are you still on?
And that concludes my business, Your Honor. May I be excused?
Yes, sir.
Thank you.
And can I join Mr. Warren, Your Honor?
Yes.
Thank you.
Yes, sir. Yes, sir. I'm just on. I got COVID, so I'm just on the toilet. My body hurt. I'm on.
Okay, that's fine. I appreciate you being here. I'm sorry you're not doing well. I don't think this will take real long. Mr. Abate, you ready to talk about Ms. Scott's case?
She is the co-defendant to Mr. Watson. They should track together. The hope is that she will be a cooperating witness in the.
Hello?
Hey, Mr. Adams, I don't think they can hear you. Sorry.
So the cases should continue to
Follow Mr. Watson's case. All right. Mr. Adams, do you have all the discovery in Ms. Scott's case? Hey, Mr. Adams, can you hear us?
I can't hear you.
Can you hear me now?
No,
Well, how are you responding if you can't hear me?
I mean, call it off and come back on, okay?
Okay.
Yes, that was my children's school. I'm sorry, you guys.
That's okay. Mr. Adams, can you hear us?
I can hear you now, yes.
Excellent. All right. My question for you is whether you've received the discovery in Ms. Scott's case.
We have, and I think we can be able to resolve the case. We're waiting on commissioners. But I told Mr. Body, I think we'll be able to resolve it. Not today, but very soon.
Okay. And that's what Mr. Abate was saying when he was a little further away from the microphone, that he'd like Ms. Scott's case just to keep tracking Mr. Watson's, but he envisions Ms. Scott's case as something that'll work out. And I'd leave it to you all whether it works out in advance of Mr. Watson's trial or not. It may be not my business, but we certainly will keep Ms. Scott's case moving along. Ms. Scott, you remain on bond. Whatever those conditions of bond are, continue to apply to you. If you need them modified for any reason, you need to let Mr. Adams know, and then we can have a conversation about that, okay?
I got you, sir.
Good. All right. Well, you take care of yourself and get better, all right?
Yes, sir. Thank y'all.
Okay. Bye-bye.
Thank you.
All right, Mr. Adams. So, Mr. Adams, you're getting ready for the Brandon Way trial on either the 23rd or the 30th, right?
On the 30th, correct.
Okay. All right. Thank you, sir.
Thank you.
I can talk to Mr. Watson after we do this bond thing. You don't need to stick around for that. All right.
Thank you very much.
All right. Case number, please. This is one of the co-defendants to Sony Music's latest and greatest amazing hip hop superstar.
Excuse me, Judge. Do you want me to leave?
Well, I don't want you to leave, but you're free to leave.
What you mean you don't want me? Do you need me to stay though?
I don't need you to stay. I just didn't want you to think that I wanted you to go away, but you're free to go. You don't need to stay.
Yes, sir. Thank you, Judge.
All right. Have a good weekend.
Yes, sir. I will.
I don't want you to stay, Mr. Abate. Yeah.
Your Honor, the case number is 22 SC 184386.
There it is. And it is Mr. Wilson we've already dealt with on this issue.
Yes.
And now we're dealing with Mr. Hall on this issue.
Yes.
Okay. And not Mr. Pepper.
Yep.
Okay. And Mr. Hall is not here. We didn't ask to have him brought over because Ms. Fagan is keeping him in the loop. And is there I know there had been an order circulating, but I needed to hear a little bit more about, well, let me do one other thing just so I think we can shut down the Zoom too. Ms. Jackson, I think we're done for the day. We're not, I mean, I got a little bit more work to do, but there aren't going to be any pleas or anything like that that are going to be flowing. So you are free to go. And Ms. Rivers, you also are free to go.
Okay, thank you, Judge. See you Monday.
Same.
Thank you, Judge. Have a good weekend.
You too. Bye-bye.